Hello, I'm David Roger, General Counsel for the Las Vegas Police Protective Association. In this video, I want to talk to you about how the courts view your motive or your decision to make a stop or a search based upon the Fourth Amendment. And so let me give you a couple of examples of what we're going to be talking about. Example number one, you conduct a vehicle stop based upon a traffic violation, but you really could care less about issuing the traffic ticket, but instead you are interested in the person inside the vehicle and you want to be able to conduct a records check and all of those things to determine whether the person is up to no good. Another example, we see this quite frequently in high-level narcotics investigations. We have a wiretap up and we receive information that a particular person will be driving a particular vehicle that'll be carrying a large amount of drugs. And so the narcotics detectives will ask patrol to make a stop on some bogus issue in order to be able to search the vehicle because they have probable cause that drugs are inside the vehicle. Another example might be a case that we've talked about in the past where an officer says that they do a pat down of an individual, they feel a crack pipe, they recover the crack pipe, and the question is, can they conduct a search incident to an arrest, because even though they know that they always just write a citation, they don't conduct the custodial arrest for narcotics paraphernalia. And we talked about following a process and going ahead and hooking the person up and conducting a search incident arrest. If you decide afterwards to issue a citation, so be it, but you have still conducted a search incident to an arrest. So the courts have explained over the years that when they're looking at search and seizure issues, the Fourth Amendment test is objective reasonableness. Is the search or seizure objectively reasonable? Much like your use of force, would an objectively reasonable officer under the same circumstances use deadly force? And so a case that discussed this issue is Ashcroft versus Al-Kid. And I'll give you the case, but it's a 2011 U.S. Supreme Court decision. And in that case, right after 9/11, Attorney General John Ashcroft issued a directive to U.S. attorneys to apply for material witness warrants to detain individuals who may have been involved in the bombing or may be involved in terrorism. And a material witness warrant is where you apply to the court, you show reason to believe that the person may have testimony that is important to a case or relevant to a case, and the court issues a warrant, just like a bench warrant. And so Al-Kid was a alleged terrorist, and Al-Kid was arrested on a material witness warrant. And the Attorney General never called Al-Kid as a witness, and after he was released from the warrant, he filed a civil rights lawsuit against the Attorney General saying that the material witness warrant was bogus, that it was really motivated to stop him from going back to his or her home country, and that it violated his rights. This is what the Supreme Court said. Fourth Amendment reasonableness is predominantly an objective inquiry. We ask whether the circumstances viewed objectively justify the challenged action. If so, that action was reasonable, whatever the subjective intent motivating the relevant officials. This approach recognizes that the Fourth Amendment regulates conduct rather than thoughts, and it promotes even-handed, uniform enforcement of the law. Regardless of what your motive is, if you have a legitimate basis to stop an individual or conduct a search, no matter whether you have ulterior motives, the courts are going to look at whether your seizure or your search was objectively reasonable, and if there was a legitimate exception to the warrant requirement. And if so, your motive is irrelevant. And so when you make that vehicle stop, regardless of your motive, as long as you had a reasonable suspicion to stop the vehicle or reasonable suspicion to detain an individual. Regardless of your motive, the courts are going to uphold your seizure, your detention, or your search. As always, contact me at droger@lvppa.com. Check out the mobile-friendly website, davidroger.us, and thank you for all that you do to protect our community.